Good evening, everybody. Once more, welcome to Trailblazers Hour. My name is Gina Isaka, and I'm joining you from South Africa. The Trailblazers series is a youth and young professional-led knowledge space under the Share Screen Africa. It was created to spotlight emerging voices, fresh perspectives, and bold leadership shaping our current and future climate and environmental action. The Trailblazers community recognizes that young professionals like us are not just the leaders of tomorrow, but active drivers of change today. Tonight, we are exploring the existing gap on policies. So I'm going to hand over to the host of this evening, Soletu Sitiki, who is going to introduce the speaker and get the conversation going. Soletu, the floor is yours.
Thank you so much, Gina. Once again, welcome to Trailblazers Hour. My name is Salita Satiki, and I intend to be your wonderful host this evening. So today we are going to be discussing what happens when wildlife causes damage, focusing on law, responsibilities, and compensation. And with us is Mr. Titus Maluleke. So Titus Maluleke is an environmental officer and an environmental inspector currently working at Ekurhuleni, the city of Ekurhuleni. He both has he's pursuing his environmental matters, focusing on environmental justice, equality, and pollution dust. Titus will unpack today South Africa's legal framework for damage causing animals, the gaps in current policies, who is liable when wildlife causes harm, and what practical solutions do we need in order to improve governance and enforcement. So, without further ado, Mr. Titus, are you ready to take us through your presentation? How did you find love for environmental law? How did you find yourself in environmental law, considering that you have obviously background in law?
I think my journey began through the enrollment of a nature conservation diploma at Tshwane University of Technology. So, but it was inspired mainly by growing in Limpopo, being exposed to the nature. So, and later on, when I progressed through the ranks of within SANParks, so I developed the passion for environmental law. So I realized that actually, so after being exposed to various components of nature conservation, so my passion lies within the environmental law. So, and then that's when I decided to also pursue my LLB degree so that I can have a deeper perspective and also even the application of the environmental law.
Wonderful. Without wasting your time, Mr. Titus, and of course, our wonderful audience's time, you may take us through your presentation for the day. We hope to learn more, especially when it comes to environmental related issues. Floor is yours, sir.
Thank you so much. Before I start, so I simply want to put this disclaimer right across that this presentation is my personal opinion and the view and my view also, and is not necessarily that of my employer. So, so I just wanted to put that across so that I can be able to highlight that the information that I'll be sharing, so it will completely be my opinion, and it doesn't serve as a legal advice. So, and anyone who want to apply the information can be able to do so by relying solely on the advice of the legal advisor. So, and it cannot be held, I cannot be held liable for any prejudice or damage resulting from any form of the content of this presentation. Thank you so much. Okay, thank you so much for the opportunity that I've been granted today to share my experience and also even the knowledge that I've gathered throughout my career. So the presentation, my presentation outline will cover the following: the legal and policy framework governing damage-causing animals in South Africa, the role of national, provincial, and local governance, delictual liability arising from wildlife-related damage. In this case, it will be any damage causing animal, and also policy and governance gap within our current legal framework, and also human life conflict and community impact, just the picture as to how does the wildlife impact our society that we live, since we share their boundaries, and also even lastly, practical solution for balancing conservation and rural development. Okay, so in South Africa, so I will simply just share the legal framework from the national point of view, and also I'll be outlining the legal framework from the provincial point of view up until, from national up until the provincial point of view. So we'll be covering the provision from the Constitution of South Africa, National Environmental Management Act, mainly, which serve as a mother legislation, and also some provisions from the specific Environmental Management Act, which include, in this case, your Environmental Management Protected Areas Act, 57 of 2003. So in South Africa, so we have 9 provinces. So, and currently we have 9 we have 9 ordinances. So, but some provinces before, those who know the history of our country, we used to have 5 provinces. So Transvaal, your Cape, and also even your Transvaal, Cape, and also even Orange Free State. So, however, some of the ordinances, they are still active even up to today. However, since we have 9 provinces, so some provinces have solely they're still sharing the ordinance, and some they have began the journey of promulgation, so that they can be able to make sure that they amend this provision of the ordinance. So in Gauteng province, whereas a damage-causing animal is governed by Nature Conservation Ordinance 12 of 1983, which previously was recognized under Transvaal Ordinance. So Limpopo, Nature Conservation Ordinance, but currently is governed by Lima, your Mpumalanga. So, and same ordinance. So, and also even Northwest. So they used to share this ordinance. However, there is currently new ordinance that has been promulgated. So, and KwaZulu-Natal also. So it used to have Nature Conservation Ordinance 15 of 1974. So, and it was largely supplemented by Ezemvelo KZN Wildlife new ordinance. So, and Free State Ordinance is governed by Nature Conservation Ordinance 8 of 1969. Western Cape, so there is a new one that has been recently promulgated. So, and there is a serious crisis in that particular ordinance, because it doesn't have any provision of damage-causing animals. So previously, Eastern Cape, I think it's Ciskei, and also even Transkei, and also even part of the Northern Cape and Western Cape used to share one ordinance, so which is Cape Ordinance 19 of 1974. So, and the current ordinance of Western Cape, so it doesn't have this provision that I'm talking about, because it was not recognized at the national level. So I believe I will be able to dissect that as I go further, and also even the Northern Cape Ordinance. So they is the one that there is a new ordinance that is currently promulgated. I think it was in 2009. So that is governing the damage-causing animal. So when you look at our Constitution of South Africa, this serves as our supreme law of our country in South Africa, which came into effect in 1996. So, and when we look at Section 24 of the Constitution, it provides the right to environment. It simply states that everyone has the right to environment that is not harmful to their health or well-being, and to have a right to environment that is protected for the benefit of present and future generation. So the Constitution, it set out the constitutional principles. I think on the same part of sustainable development, environmental justice, public trust doctrine, and intergenerational equity, and also even cooperative governance in section 41, whereby it encourages all the three spheres of governance to work together in managing any environmental governance. So, and when we look at the Schedule 4A, so it also provide a functional area, it serves as a functional area, and also provide provision for concurrent national and provincial legislation competency for national department, and also even for a provincial department to administer protection of environment and also even nature conservation, excluding your national parks, national botanical garden, and marine resources. So in this slide, I've simply outlined the two different provisions of the schedule. So I've already explained Schedule 4, as I indicated that it serves as provide a concurrent competencies for national and provincial authorities in terms of administering any nature conservation related work, your environmental management, indigenous forest, and also even agriculture. So those who are aware, as I've indicated on the ordinance previously, the ordinance for nature conservation is used to be within the departments of agriculture. So some of the department, even today, the functions still sit within the Department of Agriculture, especially at the provincial level. So, and when you look at the Schedule 5, it also provides exclusive provincial competency, whereby this is very critical in relation to the conservation matters, especially in relation to damage-causing animal. That's why, so when there is any case whereby the animal, damage-causing animal has escaped the protected area, so the provincial department will normally have assume responsibility and respond so that they can recapture or eliminate it. So, and it's very important that we understand that this function, especially Schedule 5, it simply says that this function of managing damage-causing animal, it cannot be administered by a municipality, so but only provincial authority. However, so if there is any assignment of this function to the municipality in writing by MEC, they can be able to execute it. But from empowering provision from the Constitution, so province is the one that has the authority to run with it. So in terms of, I'll be discussing the draft guideline for the management of damage-causing animal in South Africa. So as I've alluded earlier on, that when you look at the history of our country in relation to damage-causing animal, so before and even currently, they are still managed within the provincial ordinance. So each and every province, they have their own ordinance, and they have outlined as to how are they going to manage this animal. However, our national department, as I've indicated in Schedule 4, they have assumed the responsibility so that they can be able to provide the guideline for the management of damage-causing animal, so that there can be uniformity in South Africa, so that even the province that need to they will have to amend so that they can align with this guideline. So in 2010 and also even 2016, so the National Department published the norms and standard to serve as a guideline for the management of these animals, of damage causing animal. So the newly draft guideline for the management of damage causing animal, it was published on the 2nd of July for the comments, and also it was closed on the 2nd of August 2026. So for everyone to submit their submission, so that they can be able to make sure that their input is considered on the draft, so that they can be able to see where there is a shortfall. So I believe that this was a public involvement of interested and affected parties to be able to have a say in the final outlook of the guidelines. So mainly the guideline purpose is to establish national consistency, promote evidence-based management, and also reduce unnecessary destruction of wildlife, and encourage preventative measures, and improve accountability and reporting. So it's very important that we sit with a lot of damage causing incident in South Africa. So whereby you find out that they are not reported, and the people who are the landowners who are responsible for such, they get away. However, so this national guideline, so it need to take into consideration to improve accountability and make sure that there is environmental justice. So, and the key principles that they focus on is to make sure that protected areas, they prevent this, and also encourage monitoring of the fence line, so that they can be able to make sure that if there is a damage, they fix it, so that they can be able to prevent damage causing animal, and also adaptive management, so that there can be a cooperation between different stakeholders in terms of reporting, and also even human intervention where possible through the stakeholder engagement, and also even a reporting platform, and also even scientific decision from the universities, so that they can be able to professionally criticize the law, so that they can be able to give effect to the new changes. And as the last one, stakeholder participation, so that interested and affected parties, they can be able to form part in terms of the future of this new way of doing things in relation to this the guidelines. So so it's very important for us that, for example, one of the key important thing that I have observed in this guideline is that especially on the definition, so it now consider that damage causing animal, it can be any animal that causes harm to the livestock, to the livestock, to the irrigation, and also even human being. So, and previously, when you look the provincial ordinance, and also even other norms and standards that came into effect in 2010 and 2016, they didn't take into consideration the human elements or the damage to personal damage in relation to the human. So I must compliment the drafters of the new guideline that they have taken into consideration the aspect of damage towards personal damage that can result in fatalities or people losing the functions of their bodies, body parts in some sort. So on this part, so I'll be discussing the responsibilities of the landowners, especially the legal duties. So when you look at the National Environmental Management Act, so it lays out the duty of care. So principle, when you look at under, I think it's chapter section 2. So the following individuals have and they can be held liable. So, and before I go further, so if you check the guideline that I've referred to on the previous slide, so it now explain also even the duty of care. So hence I've highlighted that they have now resorted to correcting the empowering provision that was missing from the legislation so that they can be able to improve better environmental governance. So landowners may be expected to maintain the boundaries, the boundary fence, especially if they are keeping wildlife within their premises. So they are expected to comply with the Fence Act together with this new guideline. So they're expected to implement preventive measures so that they can be able to fix fence timely, so that they can be able to prevent the cases of damage causing animal. So, and also even the turnaround time. So they are expected to comply with permit condition. So, and I believe that the state, especially province, if they can prove negligence from facility from anyone who has the permit, so they can be able to make sure that they cancel the permit if there is a lot of cases that are reported. So, and also they are encouraged, people are encouraged, or general public are encouraged to report any escape wildlife, so that they can be the province can be able to respond and determine and assess as to whether they recapture the animal or they apply the method that will be appropriate in making sure that there is no further injury to the society. So, and also the neighbors are protected, are expected to protect, to make sure that the community is protected from any foreseeable risk that can be seen, and also the example of risk that people they can be able to experience is your predator-proof fencing. So you are encouraged when you obtain the fencing that the provincial authority will be able to make sure that the following your predator-proof fence comply with the requirements of the legislation. So, and also even the permit. So, and if you most facilities, if they don't comply, they're able to revoke the permit for hosting the wildlife. So, and when you look at your livestock guarding animals, so they are now encouraged, for example, the use of dogs in chasing wild. There are some dogs that are trained to deal with the damage causing animals. So new guideline, it makes empowering provision for everyone to use the use of dogs, and also even early warning system, so that they can be able to be better management, and also even wildlife monitoring through the use of cameras that are able to take your that is able to take the pictures and then report right away. So if there is any form of incident, especially in the farmers where there is irrigation, so and even trap cameras, so they are able to be used so that they can be able to monitor what is especially on your water holes, so they are able to track and see what species are there so that they can be, if there is any urgent intervention, they are able to implement it right away. So government obligation, so as they have a fiduciary duty, as outlined in Schedule 4 and 5 of the Constitution, so they can be held liable. So especially if there is any form of civil claim that is initiated by any person who suffered any form of a loss or a damage. So, for example, National Department, Government Department, DFFE, can be held liable. So provincial ordinance, provincial departments, and also even the provincial bodies that are within the province that are tasked with discharging the function of your protecting the biodiversity. Example include Cape Nature, your MTPA, so they can be held as be held liable, and also even as MVELO. Provincial government department like LIDET, and they can be held liable. So so it's very important that even the permit holder or even the authority that issued the permit, where someone doesn't comply, especially if they're during the process of civil claim, if they are able to establish the elements of a delict during the legal process, so liability is able to extend to everyone who played the part. So in South Africa, so if anyone who suffers any damage to the life, for example, personal damage to their property, so we have a branch of law within South Africa which is called a law of delict. So anyone who who suffers as a result of damage causing animal who suffered personal, maybe let's say your personal damages or damage to the property, so can approach the courts through by instituting the delictual claim. So and you are expected to make sure that in proving that the person that you are instituting against, they have in order for them to be held liable. So there is following elements of delict that must be proved. You have to prove that indeed you suffered as a result of the conduct of in this case, I can simply say maybe as MVELO, as a case study. So, and also you have to prove their wrongfulness from their part, that if, let's say, there was a fence that was not fixed and someone was attacked by a leopard or a lion, so you will be able to prove that actually there was this conduct that took place. There was a wrongfulness from SMVELO. They failed to take a duty of care, and they are at fault, and because they became negligent. So, and also causation, and you also will have to prove the damage. You have to have suffered the damage so that you can be able to successfully claim your and claim your the damages that you have suffered as an individual. So, and it's very important that all five elements be established during any form of civil claim instituted by any individual. So, failure to do so, to comply with one of the elements, so your claim won't have won't be successful. So, and currently, as things stand, so we don't have a national framework whereby any person who suffer any damages, personal, either personal damage or damage to the property. So they can be able to maybe approach an entity and also that is uniform and seek relief for what they have covered. So there is a research, there is a need for a research in this area. So especially for the establishment of this financial institution like your RAF, so that whoever suffer the expense at the expense of anyone who either province or any private landowner can be able to institute the legal claim so that they can be able to be assisted. And because currently, as things stand, this process it can be instituted through through the assistance of a legal practitioner, and to many individuals who doesn't have the financial muscle to fund the legal bill, they continue to be prejudiced and suffer and not receive environmental justice. As they, I'll be able to articulate this through one of the case study that is publicly known in South Africa, whereby even the previous public protector to Lima Donsela investigated the case. It was published in one of the TVs. So, and the individual who suffered the personal damage, they haven't received justice even today because civil process, it take time. So, and for example, if someone doesn't have financial means, they tend to suffer and not receive environmental justice. So wildlife damage and delictual claim, as I've indicated above, typically include the following: property damage. Property damage, for example, we can see wildlife escaping, damaging the fences, especially in the agriculture around Kruger. So you'll find out that they will damage the fences because the communities they are adjacent to the protected areas, and damage towards the infrastructure, such as your windmill, your crop, and also the livestock losses by especially your jackal, and they've been, and caracal have been reported to be going to be one of the species that is causing that is causing a serious loss to the farmers, and also even your hyenas, especially the cats. So, and also even personal injury, human injury caused by a dangerous animal, the leopard, your hippo, your elephant. So one of the case study that I will be explaining is in relation to the leopard. So, and also even the elephant in Hluhluwe. So, and also even economical loss, this loss of productivity, especially to the farmers, they are able to suffer at the expense of damage-causing animals. So the policy gaps in South Africa include the following. There is no, as I indicated, there is no uniform compensation scheme. So, and as I indicated, so currently we don't have the national legislation or empowering provision that is binding from your member, that we can, any person who suffer can be able to use that particular provision. So, and so even in the newly promulgated guideline that was published to encourage everyone to submit their public comment. So there is no provision whereby anyone of compensation scheme. So, and I believe that this is one of the areas whereby the national department, they can be able to do a research, and also even the scholars. So they're encouraged to establish research findings, so whereby they're able to submit their findings to the national department, so that they can be able to see how best can this be done, because especially to people who are financially disadvantaged, they continue to suffer at the expense. There is a gentleman from Lulue that I'll be explaining. So he doesn't have both hands because he was fighting with leopard. So, and he survived. And to such individual, and also even some who lose financial income. So it's so sad to find out that they continuously go through the process whereby they don't receive justice. So it's very important that communities get a relief, because they frequently absorb costs associated with conservation effect or failure to control or to manage damage-causing animal. It results in community retaliating or not receiving justice. There is inconsistencies amongst the provincial ordinances. So, and that which is violating the constitution, because if you check, I think there is section 172, whereby it provides that any action or any act that is against the constitution must be declared null and void. So most of the provincial ordinance, if they can be any, they can be taken to task through legal challenge. They will be declared unconstitutional because they are inconsistent with the national legislation. So there is unclear liability standard. So there is a limited guidance regarding state liability. However, new published guideline, at least it makes a provision of more light. However, still there is no a clear liability whereby the people, they can be able to receive compensation. However, liability in this case, it goes to any person who failed to take a duty of care, who was negligent, and also even the provincial department, if they fail to act and fail to carry out their fiduciary duty in terms of the Constitution, Schedule 4 and 5 of the Constitution. So, and a limited benefit sharing, community bear the cost but receive a few benefits. So, and that's one of the things that is causing the community to resent towards the entities around where there is a protected wildlife entity. So there is a weak community participation, especially in terms of submission of the comments. So it's very important that it's very important that disadvantaged communities, they are encouraged, and also even national department must not only rely in publishing on the newspapers, especially in terms of participation. They need to reach out to the communities with the method that is publicly accessible to everyone, so that they can be able to have a right to environmental participation in the decision that shape the future of South Africa. So this is the case study from KZN. So whereby there is this gentleman that was attacked by a leopard. So there is another one who lost both of his hands whilst trying to fight with the leopard. So, and fortunately, he managed to survive. So, however, he doesn't have both his hand. So I was following his case closely. So, and it's one of the case that one of this incident that encouraged me to also pursue this environmental law, because I believe in environmental justice. So I hope the gentleman will receive justice one day, so that he can be able to um, have a peace of mind, and also even the compensation for the damages that he suffered at the expense of the leopard that escaped Ehlihluwe. So, and one of the most important thing that I've observed is that there is the challenges continue to be there, because when you look at the fence maintenance, so on the documentary that was aired on the TV, they are saying that the provincial department failed to enforce the PFMA duty on the contractor that was appointed, so that they can be able to make sure that the fence that was reinforced is able to be up to standard. So, and they realized that even even today, so the fence, it continuously get damaged. So, and I've worked in one of the entities like your SunParks. They are very responsive in terms of your management of the fence line. So I believe that national department, they can be able to share the skill as to how best can we be able to make sure that this challenge is resolved through knowledge sharing, and also make sure that any financial losses that people suffer, so they're able to compensate, and also make sure that also even the wildlife that has escaped the boundaries of the protected areas, there's able to be a plan around. So I was so impressed when I saw the initiative done by SunParks and also even MTPA, whereby they've signed a memorandum of understanding in the Mpumalanga province, so that they can be able to prioritize this project of damage-causing animal. So, and beside having empowering binding empowering provision, so they took initiative so that they can be able to work together and respond, because most of the buffer zone have been encroached around Kruger. So, and I think it's in Matsulu, somewhere around Mpumalanga, there was a retaliatory killing of the lion that was killing the wild stock of the community. So they managed to trace it and then killed it. So, and also it's very important that there is a proper response right away, and also even people who doesn't comply with the permits, especially in terms of keeping the wildlife. So they are not held liable. So, and so it's very important that so we address the issue of the permit, because some they are delayed, and you find out that they don't familiarize themselves with the condition, and also even the consequences of non-compliance. So the absence of a compensation framework in a form of RAF continue to be a thorn in the flesh. So, and I believe that I call upon the researchers to take up this initiative and analyze it and come up with findings that can be able to provide informed scientific information and knowledge that can be able to shape the direction of our environmental management. So I believe that we can be able to include community and also even the wildlife, so that the conflict can be minimized and create a harmony and a successful environmental management. So I've shared the link here is for this. There is a documentary whereby they are explaining how this man survived from the leopard, whereby so most people, they don't survive this incident. So the community, the families that stays behind, especially if they've lost a loss of income, they deserve to environmental justice. So I will end it here. Thank you so much.
Right. Thank you so much, Mr. Maluleke. That was quite informative and a mouthful. Without further ado, I am quickly going to go to a question that is in the chat. It comes from. So I don't know if this is a question, but Sam Farai says that a key gap is that the aspiration of the draft of DCAs is representative, but is reduced preventative actions or frameworks or approaches are flagged. Perhaps a structuring in the guideline is important. Secondly, guidelines are not norms and standard, and thus may not carry the same legal enforcement, which means it should actually promote flexibility, and that aligns better with adaptive management principles that the guidelines aspires to. If you can share perhaps an example where you've seen when, like, an example when something has happened and you've seen how delictual claim actually works. How do people bring a claim for delictual claims? What happens when you've been harmed by an animal and you intend to bring a claim against that particular organization, and how do you bring about that? Basically, they're asking you to explain further on how delictual claims are actually brought and how they affect individuals from different backgrounds.
All right. Thank you, Soletu. So, in answering that question, so number one is very important to get a legal advice from a legal practitioner. They will be able to assess your claim and be able to, in light of those elements of delict that I've indicated. So, and after analyzing them, they will be able to assess the damage and be able to advise as to, in terms of evidence that you have in order to prove your case. So, and if you have that evidence, so it will be easy for you to be able to determine also even the quantum of the maybe any financial loss that you have suffered. So they will be able to establish as to if, let's say, for example, your financial damage that you are claiming is less than 350,000. So they will be able to make sure that your matter is ventilated within the lower courts. And if is anything more than that, they will be able to make sure that they entertain it and ventilate it in the high courts, any high courts of South Africa. So, and number one, they will be able to assess the damage that you have suffered, and also even the evidence that is available, and be able to provide proper legal advice, so that even when they move forward, they will be able to advise you about the likelihood of the success of the case that you want to bring across. So, and one of the key legal action that I have served the communities well is instituting your class action, whereby if is the community have suffered the same loss from a particular entity, they are able to join the hands and be able to make sure that they support each other, especially if there is any form of evidence, witnesses, so they are able to consolidate that so that they can be able to build a strong case. So, and make sure that whoever is liable is taken to the task and deliver environmental justice.
So, Dr. Pillay says, Titus, you have the unique distinction of being both a professional natural scientist and an environmental lawyer. In your experience, where is the single greatest policy gap that prevents effective human wildlife conflict resolution in South Africa today? And notably, what one challenge would make the most immediate difference?
Okay, thank you, Solechi. So I think that one of the important gap, especially assessing from environmental science and legal. So remember that any environmental work that is carried out today, so is the convictions of our country in a form of either the ordinance or the national legislation. So in this case, where there is a gap, the guideline, so they are not they are not actually binding compared to your norms and standard. Uh, so I believe that's where there is a gap, because it creates a flexibility, or else if maybe let's say national department was gonna take the stand or to initiate the good work that they've done under the guideline and put them within the norms and standard, they become binding to all the provinces. So there is no province that can choose and pick. So they will have to be enforced throughout by all the provinces. So I believe that's where there is a gap. And I believe that also even science have a voice in also criticizing the legal gap through through a research, so that they can be able to drive the change that is practical, and also be able to deliver um, uh, that will be able to deliver the result that we want to see. Because there is one thing to have the legislation, but if it's the guideline or the legislation, but if it's not enforced, so, and you find out that in this case, we have entities like your Center for Environmental Rights, and also even your Endangered Wildlife Trust, whereby if they challenge your national department, so if they take some decisions that are not practical, that are not in the best interest of the environment. So I believe that's where there is a gap. So the science practitioners and legal practitioners, they need to sit in one in one table, so that they can be able to share ideas. So, and one thing that I'm happy about is that the person who is currently consolidating the input, the comments, uh, I was discussing with him last week. So he was so impressed about the participation that was that came through, whereby there is also contribution from science and also even the law that is shaping the desired output, and whereby I believe that this question also will be highly important after the final publication of the draft, so that we can be able to see whether science and law managed to get the true representation in terms of the practicality.
All right, I have noted that, Mr. Maluleke. Well, quite frankly, I do believe that there will always be a gap when the scientists and the lawyers are not coming in together. Because if now we are talking and discussing environmental related matters, where scientists are on the ground, because when it comes to these matters, scientists are on the ground and the lawyers are just part of the legislature. They're just there to make sure that the legislator is writing or is making sure that the legislation itself speaks to to science and to the environment, while also making sure that all the legality parts are met. So yeah, I think it is important that the lawyers and the scientists, they sit down and have a conversation and see how can we then progress into making sure that we have a legislation that is standardized, and that people are able to then now say we have a legislation that works not only legally but also it is practical when it comes to the science background.
But yeah, thank you very much. Yeah, Mr. Maluleke, thank you very much for insightful, inspirational presentation. So yeah, Maluleke is my ex-classmate, so we studied together at TUT, our first year. But yeah, I just wanted to touch base on the legislation and that gap that Dr. Pillay was talking about, but I think you've addressed that. But one other thing, I just got reminded by that case study about the Shushuwe, and the man was attacked by a leopard at Shushuwe. I don't know how do they deal with claiming specifically around that area, because we know that one of the biggest issues there is that some people deliberately remove the fence, and I've experienced people removing fences whenever they are striking, they remove the fence. They want the jobs inside the park, so they remove the fence, and then some poor people then get affected by the leopards and other danger-causing animals. So I don't know how do you go about with it to make sure that the claim is legitimate and to deal with the negligence that comes with that, specifically with people crouching into nature reserves and removing fences. Thanks.
Okay, thank you, Mr. Sevilla, for that question. So in relation to the claim that are initiated as a result of encroachment of the buffer zone, so such I believe that they won't be able to stand the test of time, the test of time in court. Number two, so in relation to the claims that were architectured intentionally, so also so they won't be able to stand the test of time. So as I've indicated, or also on the elements of crime that the elements of delict, so I've alluded there that you have to prove all of them. So and if especially on the fault, if the fault it was not as a result of the negligence of maybe let's say Ezemvelo. So the if the claim it cannot be it cannot be successful because it was architectured. So if in case there is the doing of the provincial authority and they fail to take a duty of care, that's where they can be held liable. So, but if as things stand, the community, maybe let's say they intentionally damage the fence to allow access of wildlife. So that lane, if it's also noted, so the Ezemvelo can be able to bring that as part of their defense against the civil claim that can be instituted to indicate that from our side, it was not, we took the duty of care. It was not, we're not negligent in this part. So, and I believe that the presiding officer will be able to evaluate the evidence that is brought before him or her, and then be able to decide in relation to that. But as by evaluating those facts, so it's clear any intentional and architectured damage, so it cannot result in a successful claim that if anyone can be able to institute them. And also, even the communities that encroach the buffer zone, that is no touch, that is no go area. So the risk to suffer more because they've encroached the protected area. Thank you.
Right. Thank you so much, Maluleke. I am going to then now go to Dora Ayabare. Dora Ayabare, are you still here?
My name is Dora. Thank you, Mr. Titus, for that presentation. Mine on my side, I would just like to share a few things based from the gaps which have been identified and what has been going on in the discussion. So, sharing on our side, this is Uganda. Apparently, you are talking about the framework. We are backed up by the national constitution, first of all. And then on the other side, what is quite unique with us, which I didn't hear with what the presenter was mentioning, is that we have the wildlife law, the Wildlife Act, which is well elaborated. It has areas of compensation, it has areas of education and awareness, preventive measures, and it goes ahead to have stringent captions, especially in penalties. For example, things to deal with wildlife. If it is an endangered species, we are looking at a fine of 20 billion Ugandan shillings. And then we are looking at life imprisonment, or you can take on both. And this is what we have been going around telling and educating. We are not just telling, educating the people, first of all, about the law. What does the law require you as a person near this protected area? And on the compensation, it has been coming up, especially when it comes to human-wildlife conflicts. We have a compensation scheme which categorizes where there is death, there is compensation, and where there is livestock damages, animal tax, things like also where there is that conflict, we have to come in. But the question remains, where were you? Were you in the protected area or not? If the animal found you outside, then we can compensate. But that is not enough. You can never compensate people and finish them out. What you need to do, we are looking at other measures. Number one, which we are forwarding ahead, is the education and awareness. When it comes to the law, people living with animals, the harmonious living with wildlife, and we attach value to wildlife. But we also look at, before we go so much into compensation, what are the other alternatives in terms of sources of income for the people? For example, we are saying do not have your eggs in one basket. So that if, let's say, maybe you're a fisherman and you're relying on the water, have a garden somewhere. If it is maybe a garden, have another option, maybe have beekeeping as your alternative, so that when you face one damage, one loss, you are not completely taken out. And that way we are trying to bring in different support communities in establishing these alternatives so that they can attach value to wildlife on how it is contributing to them, but also realizing that these animals must stay, they have to be kept around. So in stakeholder engagement, where you are saying there is weakness, we are looking at things like workshops, meetings. They participate, especially when we are doing reintroductions, when we are explaining compensations. We don't only explain to the chairman or just a few individuals. We involve the local people, and we can also engage them in the community projects, wildlife scouting, so that they monitor these animals. They are custodians in the community. So you find that through that, you will engage people and they get to learn about wildlife. They get to appreciate it, especially when it comes also resource sharing, because like for our side, there are about 11 national parks, and you end up saying that every gate collection fee, you have a certain percentage you are giving to the people. to construct roads, to have their schools, to have hospitals, and with that, people keep on appreciating wildlife. Even if you talk so much about the law, even if you do so much, and you're not putting things into the community's hands, you are literally going to not to touch a lot. So for me, I would say that all this that we are discussing, maybe there is something planned from our side, but on the legal framework, we are well established and people are being compensated because there is a budget the government allocates for people to be compensated just in case. And also technology, buffer crops, these buffer crops like tea can prevent animals from coming in. Anyway, thank you so much. I don't want to take so much of the time, but that was my contribution. Thank you, Dr. Titus or Mr. Titus. Thank you.
Right. Thank you so much, Tora, for your contribution. I think obviously each country can learn from another country when it comes to environmental related issues. We cannot say South Africa has the most developed legislation or has the most properly well planned framework when it comes to legal the legal side of environmental law. There's always a lot we can learn from other neighboring countries. Of course, I can hear and note that Uganda seems to be quite progressive when it comes to compensation related issues. But also, I think I can also comment and say one of the other things that might actually cause delay when it comes to compensation in South Africa is that there isn't something like road accident fund, because you see with road accident fund, we know where the source of compensation comes from, and it is generated through fewer levies. But now when we're coming to nature and environmental compensated related issues, we also know that the money now comes from the government and it comes from the taxpayers. And most of the time, these organizations are getting funds from donors and other sponsors. And usually that money is so that organization can be kept. It can be, people can be paid, and basically everything is done accordingly. So I think obviously that is another contributing factor as to why there's a delay when it comes to compensation, when it comes to environmental related issues, and why justice might look perhaps delayed, because there's obviously fund related issues when it comes to environmental related issues. So yeah, I don't know if you have anything to say regarding that, Mr. Maluleke, in closing.
Thank you so much, Soletu. I concur with your your sentiment that you have shared, that as the countries, different countries in Africa, we can learn from one another and be able to um, test, especially the legislation that have been applied and also assess it in the full scope, because communities they are different, so that we can be able to analyze as this model will it be applicable also when you look at your in situ conservation and ex situ conservation aspect, and we are able to make sure that um, we start from somewhere. So, and also make a meaningful contribution and allow the space for us to learn from one another. I believe that that can be a good start. So, and I will also encourage one of my friend who is working within the national department, who's tasked with this, the responsibility of leading this work, to be able to look at the work that Dora and the country have done in Uganda, so that they can be able to see as to which areas can we be able to learn from the work that has already been done. Thanks, Soletu.
And Mr. Maluleke, you have impacted us with a lot of information. And quite frankly, I've learned a lot. And I'm still going to do my research regarding some of the law-related responsibilities when it comes to environmental law and how wildlife actually has an effect on humans, you know? All right. Thank you so much. I know I said we're closing, but I believe there's a question by Dr. Sim Ferrari.
Yes, good evening. I can quickly, I'm not sure which one you referred to, but I guess the last discussion that Titus had around compensation is probably a really important one, and also the wonderful contribution from Dora. And I think the question is, what is the purpose of compensation? And why I'm asking that is, we typically convert it to some other money value, and it becomes really problematic because how the hell do I put value to the life of somebody, especially if somebody has lost their life? And there are some very interesting perspectives that a guy by the name of Jared Diamond wrote when he gave an example of something that happened in Indonesia. But the bottom line is the purpose of compensation is actually not to compensate for or likely not to be to compensate for the value of whatever someone has lost is actually being a good neighbor. It's about how you recognize a loss, how you say sorry, or how you offset all those sort of things. So that's probably a difficult space that we can certainly learn things from several other African countries. I think the Indians has got some very interesting approaches as well. But in general, the collapse of compensation discussions simply to a monetary value may actually be quite challenging, and it may even challenge some of the rights issues that some of the colleagues have highlighted. So that's probably something, Titus, that might be, or maybe even for CSK in Africa to have a particular discussion on this somewhere in future. What do we mean by compensation, and how are we fair towards people in that process? Anyway, that's just a quick comment. Thanks, Titus. I really appreciate that you put your neck out and talking about this.
So I just wanted, firstly, to say thanks for the comment, Dr. Ferreira. So in relation to the compensation, I believe that in order for us to have a very fruitful engagement, as we debate, we'll have to explore this subject, especially in relation to the factors that support why compensation should be there, and also even have a debate about the other voices and hear them, especially that discourage it, so that ultimately we can be able to assess both sides and make an informed decision in relation to the way forward. So I believe that's a better approach. That is even also followed when you within the argumentative essay. So you'll have to assess both sides and then make an informed decision. So, and I believe that if it's endorsed by the public, so then we'll be able to have a green light. So, but in relation to the compensation, my final contribution in relation to that is that in South Africa, anything that has to do with compensation as a result of anything that has to do with the compensation is entertained through the branch of law of delict. So that's whereby we are so fortunate to have this branch of law whereby the evidence that we have, it will be tested, and then ultimately we'll be able to come up with a claim that can be deemed proper according to the damage. So, however, there is a lack of the determining factors that can be able to highlight as to if you have suffered this much, then you will be able to be liable for this this part. However, I believe or not that it can be advanced by the legal practitioners, especially if they argue a case, and be able to put the strong case forward, especially looking at the factors that of the gentleman that lost both hands. So he was just indicating that now when he go to the toilet, he asked the daughter to wipe him. The dignity of that man is lost. So he has lost the ability to make an income. He doesn't have both hands. He cannot work. So those factors, they are able to be taken into account as to that particular person. He was a breadwinner. So, and you look at those factors, so, and they are able to make a reasonable compensation. So, and I believe that also even some practitioners, such as actuaries, they can be brought into our conversation so that they can be able to guide us and quantify the legal claim accordingly, so that we don't we save environmental justice and become fair to people who suffered the harm, and also be able to deliver environmental justice. Thank you,
Without further ado, and without wasting more of your time, thank you so much.